History as it happens, May 31st, 2022. The worst ruling ever.
I, William H. Rehnquist, do solemnly swear
that I will support and defend the Constitution of the United States.
I, Ruth Bader Ginsburg, do solemnly swear
will be prudent in exercising judicial power, firm in defending judicial independence.
I, Sonia Sotomayor, do solemnly swear
that I will administer Neil M. Gorsuch, do solemnly swear.
And this is as corrosive, as destructive to the Supreme Court as we've ever seen.
For years, the radical left has attacked the institution of the Supreme Court.
This is a dark and disturbing day for America.
Judging is different from politics.
The Supreme Court is a bedrock American institution with the baroque judges and their pursuit of justice through wisdom. So why has it been on the wrong side of history so often? Dred Scott, separate but equal, forced sterilization, and more. And now with the court poised to overturn Roe versus Wade, the question returns. Is the highest court in the land friend or foe of the Constitution? Maybe that depends on who you ask. We're going to ask Akhil Amar next as we report history as it happens, a podcast from the Washington Times. I'm Martin DeCaro.
To the extent that the court has deviated from the Constitution, the court has actually been worse than the Constitution. The Constitution isn't perfect, and I'm including its amendments, which have made it better. The amendments, in fact, have almost invariably made the document better, more free, more equal, added to liberty and equality. That's not true of the cases. The cases have ebbed and flowed. Sometimes, one judicial era is better than its predecessor. Sometimes it's worse.
Judging is different from politics, so said John Roberts when he was confirmed as Chief Justice 17 years ago. He was right, of course, or at least that's the way it's supposed to be. There's no place for rank partisanship on the bench. Well, a Gallup poll last year found only 40% of Americans approve of the job the Supreme Court is doing, the lowest since Gallup began tracking it in 2000. More than a third of respondents said the court was too conservative. A Pew Research poll just a couple months ago found 54% of Americans had a favorable view of the court. But over the past 3 years, the share of adults with a favorable view declined 15 percentage points, mostly because liberal Democrats have soured on the conservative majority's decisions. The Supreme Court is receiving a lot more attention these days, and not only for its rulings. The way in which certain justices were appointed and confirmed left a partisan odor. Merrick Garland, Amy Coney Barrett, you know what I mean. And just look at the reaction to the leak in the Dobbs case overturning Roe. It fell along party lines. Listen to Senate Majority Leader Chuck Schumer, focused on the ruling, not the leak.
Last night, a report came out that a conservative majority on the United States Supreme Court is ready to overturn Roe v. Wade and uproot decades of precedent affirming a woman's right to an abortion.
And on the other side of the issue, Senate Minority Leader Mitch McConnell, angry about the leak, not the looming ruling.
Judicial independence is vital, but the far left has spent years shamelessly attacking it. Democrats in Congress have endorsed plans for partisan court packing. They've sent the justices threatening legal briefs. They've scheduled sham hearings to smear judges. In 2020, the Senate Democratic leader marched across the street to the court and shouted threats at multiple justices by name if they didn't rule how he wanted.
So, is this court too partisan?
The presidency is dangerously dysfunctional today. The House and the Senate are not firing on all cylinders. The court is imperfect, but it's the one place, the Roberts Court, where, for example, conservatives sometimes vote with liberals.
Akhil Amar of Yale University is one of America's leading constitutional scholars, and he's got a new book out, The Words That Made Us, America's Constitutional Conversation, 1760 to 1840. And he's got his own podcast, America's Constitution. That's AMARICA. My conversation with Akhil Amar is coming up in a bit. So about the leak and the uproar it caused, it made me think of the court as an institution, historically. It's always been profoundly influential. Its rulings have shaped national life for generations. Take Plessy versus Ferguson, 1896. It upheld the constitutionality of racial segregation. That wasn't overturned until more than a half-century later. Now, did the Constitution allow for racial segregation as long as separate public facilities such as schools were equal? Is that really in our founding documents? Well, a lot of Americans wanted it that way. The court said so until a different court said otherwise in 1954, Brown versus Board of Ed. Now, go back to the start of our republic, and the Supreme Court has never been placed on a pedestal beyond the reach of criticism by people and politicians, often by those who simply don't like the outcome of a case, who believe the court is perpetuating injustice. But the Supreme Court's also been criticized for botching the Constitution, whatever your policy preferences. Now, sometimes those two categories overlap, as they did in 1857 when Chief Justice Roger Taney handed down the worst ruling ever in Dred Scott versus Sanford. As a matter of justice and the Constitution, it was an outrage, although not according to slaveholders. We Americans revere our Constitution, so when the Supreme Court decides such matters, it needs to get them right. But as we're going to discuss right now, the court has often gotten it very wrong. Akhil Amar, welcome to the podcast. It's an honor to have you.
Thank you for having me.
The leak of Justice Alito's draft opinion in the Dobbs case, it got me thinking, does the Supreme Court deserve, historically, even now, the esteem in which some Americans hold it? Because as we know from a young age, we're taught in our very first civics or history classes about this great institution. It is the final arbiter of our revered Constitution. But right now, we are living at a time when our institutions, are struggling to maintain their credibility. And it seems, and I might be wrong about this, the court's reputation, this court has taken a hit. But when you look at U.S. history, the court has been on the wrong side of so many issues. Why do we respect it so much?
So you're right about history, and we can talk about Dred Scott if you like, or Plessy versus Ferguson, or a thing called the Lochner era.
Yes.
So you're right about history, and you're also right that today the Supreme Court, I think, is perhaps held in less high regard than maybe 20 years ago or 30 years ago. All true. But here's what I would say. On the other side, the court is, I think, still and justifiably held in higher regard than the other branches of government, than the House, the Senate, and the presidency, and justifiably so. And so it's the least dysfunctional of our branches of government at the present moment, and it's, in general, much better than it has been at various moments in our history.
I think some of the recent criticism is about how the court appointments have come about, not only how the court has ruled in certain cases, referring to Merrick Garland, Amy Coney Barrett, etc.
If so, you can't quite blame the court for that because it's not in charge of its own replenishment quite. You have to blame the politicians for that. You should blame the presidency and the Senate because they're the ones in charge of the replenishment process.
Several days ago, in advance of our podcast conversation, you mentioned something to me about how, historically, the court often drags the Constitution down. I'm not quite phrasing it the way you did.
Yeah, I'm an originalist. Your audience might think that originalists are generally conservative politically. I count myself a liberal, a Democrat, but I believe in paying attention to what the Constitution really says and what it meant when adopted. And I'm in a tradition of liberal originalism that includes, for example, on the court, the greatest, in my view, of the Warren Court justices, Franklin Roosevelt's first appointment to the court, Hugo Black. He always carried a copy of the Constitution around with him, and he was the driving force of intellectually of the Warren Court. Now, why am I mentioning that? Because if you're not an originalist, the alternative might be, pay attention to judicial precedent, what the court has said. You're kind of a court worshiper or a Constitution worshiper. Those are, two of the main options available to you. And my claim is, for most of American history, to the extent that the court has deviated from the Constitution, the court has actually been worse than the Constitution. The Constitution isn't perfect, and I'm including its amendments, which have made it better. The amendments, in fact, have almost invariably made the document better, more free, more equal, added to liberty and equality. That's not true of the cases. The cases have ebbed and flowed. Sometimes, one judicial era is better than its predecessor. Sometimes it's worse. So the cases have fluctuated, positive and negative, whereas the Constitution has gotten better over time. And to the extent that the cases, the court, over the course of history, has deviated from the Constitution, in general, it's deviated downward. It's been less good than the Constitution and rarely better than the Constitution.
I do not revere, I don't revere anything. I'm an atheist. So I revere,
admire, greatly respect.
I revere,
hold in high regard.
Yeah, reason and intellectual curiosity, I suppose.
So on reason, here's the reason to hold the Constitution in high regard. It's the product of many minds over many years. A lot of people got to vote on the Constitution. More people were allowed to vote on the Constitution in 1787-88 than had ever been allowed to vote on anything before in the history of planet Earth. And to repeat, the amendments actually have made it better, and they've also involved a broad participation of lots and lots of Americans. By contrast, the court is 9 people today. It's been as small as authorized size of 5 and large as 10. But okay, it's a little committee. 5 out of the 9 are a majority. And it's quite possible, you see, that 5 people could get something massively wrong. It's less likely that millions and millions of people who are part of the amendment process, or back at the founding, hundreds of thousands of people, part of the ordainment process that generated the Constitution, it's less likely that all of them are going to be deluded. The famous French mathematician, the Marquis de Condorcet, an Enlightenment philosophe, since we're talking about reason and enlightenment, had a very famous theorem. It's called the Condorcet jury theorem. It was published in the 1780s, and it basically was an early version of what we call today the wisdom of crowds. Sometimes, actually, if you get a lot of people involved, there will be a lot of wisdom in that. If you're trying to figure out how many jelly beans are in a jar at the county fair, or how much a big heifer weighs or something, a very good strategy would be to poll everyone in the world and take the median guess. You're going to do probably as well if you do that as if you ask the world's greatest scientist or physicist to guesstimate the number of jelly beans in a jar or the weight of a heifer. So there is a wisdom of crowds, I believe, and the Constitution itself embodies that. The court, not so much. It's a much smaller group, and 5 people can go way off target and have in history, and to the extent that they've veered from or deviated from the Constitution, it's often been in a downward direction, less good than the Constitution, and rarely more good than the Constitution, better than the Constitution.
The reason I got in touch with you about this episode was to discuss the worst decision ever. We're going to get to Dred Scott in a moment, but one other point about the Constitution. I said I don't revere it or worship it. I really don't revere or worship anything, but I do find the Constitution, obviously, an amazing document and an important one historically. But as I've done more and more episodes about such subjects, an incomplete document. Not good, not evil, incomplete. William Lloyd Garrison called it, a pact with the devil or a covenant with death, something like that. Mm-hmm. And Frederick Douglass had the other view, that he thought it was a liberty document. It was an incomplete document. The amendment process has helped, as you said.
And just on that, we want to distinguish between the original Constitution, which in my view actually, alas, was pro-slavery. The 3/5 clause gave the South, the slaveholding South, extra credit for their slaves. And so almost all your early presidents, in fact, all your early presidents are Southern slaveholders or Northern men of Southern sympathies who have to accommodate slavery because you can't get elected otherwise. So the original Constitution, thanks to the 3/5 clause, does have strong pro-slavery biases, but of course the amendments added after Garrison and Frederick Douglass first started talking about the document, make amends for that original sin. The 13th Amendment abolishing slavery, a 14th Amendment providing for equal citizenship of black and white and birthright citizenship of all, and a 15th Amendment promising equal voting rights for African Americans. So the Constitution today isn't just that founding document that was radically imperfect, that William Lloyd Garrison harshly critiqued. It's the amended Constitution. And one of my claims has been, talking about reason and enlightenment, that the amendments have in general made amends. They've actually made the document much better, women's suffrage in the 20th century and many other things, whereas the court has sometimes been better than its predecessor and sometimes actually worse. The court has ebbed and flowed, whereas the document has actually in general, steadily improved.
That's right. The Constitution, at least in my view, it was neither pro or anti-slavery. It had elements of both, but it was a contested document right from the beginning.
But here's the point on that. Contested. I'll let you, and you and I are going to make a Constitution together, and here's the deal I'm going to propose to you, Martin. I'll let you write every word if you let me write every number, because the numbers will trump the words, and 3/5 turns out to be a massive benefit for the slaveocracy. So yeah, they didn't use the word slave or slavery. They were embarrassed by it, all true. But 3/5 is going to very predictably give a huge advantage to the South, not just in the House of Representatives, but in the Electoral College. So to repeat, and I'm going to now connect the dots, every president until Lincoln is either a slaveholding Southern plantation owner or a Northerner who accommodates slavery, because if you don't, you can't get elected president. And as we talked about before, presidents pick justices. The process of judicial replenishment is a political one. So that 3/5 clause turned out to be very big indeed in inclining the antebellum regime toward the slaveocracy.
True. However, after some time, the Senate becomes the bulwark of the slaveocracy because in the House, the North's population grows so much faster than the South's that 3/5 becomes less important over time. And as far as
not for the presidency, yes. You see, just to repeat, let's just take Thomas Jefferson versus John Adams. Very famous election.
1801.
First peaceful transition of power, it is said, although it was much more fraught than most Americans understand today. We came close to having malicious march on the Capitol in 1800, 1801. But in any event, Thomas Jefferson, every school child is taught, wins that election. Oh, but he wins it because of the 3/5 clause. More people voted for John Adams. More free people voted for John Adams. But because of the 3/5 clause, Jefferson got 13 extra electoral votes from the South. He only wins by 8, you see. So that 3/5 clause is really important in skewing the presidency and therefore the judiciary, because presidents pick justices.
I'm in the Wallensian school, though, when it comes to why the framers of the Constitution kept the word slave.
Right. And since you mentioned my friend Sean Wilentz, I'm not. So I'm going to go there and be honest here. Sean Wilentz is great. We've debated this topic. He is not burdened by illegal education, whereas I actually have a history background as well as a law background.
So you disagree with his thesis in his book, No Property
Absolutely
Man.
No Property in Man, because I said it, but you didn't hear it. I'm going to be fierce. I will let you write every word in the Constitution, and you can keep the word slavery out, as long as you let me write every number, because I'm a political scientist and a law professor and an historian, and the numbers will trump the words. So it can be as soft and gentle as you like, but it actually isn't with the Fugitive Slave Clause and other things. They just don't use the word, but they do the thing. So as a law person, we're talking actually now about the Constitution. We're not just talking about history. And I like Sean, but he's not actually a constitutional scholar, and he doesn't understand, with all due respect, that the words are going to be trumped by the numbers. Yes, so it doesn't say no property men. That's not even the essence of the thing, because actually if you've gone to law school, you know all sorts of property interests exist even in human beings, and that's not always slavery. People have property interests legally in their spouses such that if someone else actually injures a spouse, injured, say, a husband, a wife actually has a legal cause of action because the husband now is no longer able to perform certain things. That's property interest in people. That's actually not the essence of the thing. So I like Sean. That book is interesting, but it's basically way more wrong than right.
Maybe I should have you and Sean on to debate this point. Yes. Well,
and he and I have debated each other at the New York Historical Society, and we should do it again.
I missed that one. You know, you graduated from Yale Law School in 1984. I graduated from Google Law School. You know, I was researching bad Supreme Court rulings. I'm familiar with some of these, given my historical readings over time, but we'll start with Dred Scott. I'll just provide a little bit of background, and then you can explain, one, why this was such a terrible opinion, and whether it has, to this day, any lasting import. Dred Scott was a slave. His owner dies in the early 1830s. He is purchased by an army surgeon who takes him out of the slave state of Missouri and brings him to free territory, Illinois. And over the next decade or so, Dred Scott, who eventually marries, moves back and forth with his owners from free to slave territory. And that context is important here because ultimately the Civil War starts over this conflict over slavery and its expansion to new territories, new states. Dred Scott in the mid-1840s sues for his freedom under a couple of Missouri statutes, saying that he had been brought as a slave into free territory, which now makes him a free person. Justice Taney disagrees, but he just doesn't go there. He goes much further when it comes to the place of black people in America. Akhil Amar, take it away.
A truly despicable holding, and one that confirms the general claim that I made. The Constitution isn't perfect, but actually often the court has been worse. So here's the imperfection of the Constitution. Taney is the guy making the decision. Why is Taney the guy making the decision? Because he was put on the court. Why is he put on the court? Because presidents get to pick justices. And who's the president who puts them on the court? Andrew Jackson. And to repeat, Andrew Jackson is emblematic, actually, of the original Constitution that's going to deliver the presidency to basically the slaveocracy because of the 3/5 clause. Okay, so blame the Constitution a little bit because it's going to make the world safe for presidents like Andrew Jackson and therefore justices like Taney. But the Constitution, although bad, is much less bad than what Taney says. Taney says three things. First, blacks, even if free, even if born free, even if their mothers were born free, even if their grandfathers were born free and fought for the American Revolution, as many free blacks did at places like Bunker Hill. Even if all of that is true, a free black person can never be a citizen, says Taney. If you're a member of the slave race, a descendant of the slave race, this is his formulation, you can't be a citizen. And the Constitution doesn't say that at all. He just pulled that out of his ass. He just made that up. Point one.
To borrow a modern phrase about what he was doing back in 1857 was the ruling.
Yes. Pulled it out of his backside, they might have said. Okay. Point two. He says that actually Congress cannot prohibit slavery in the territories as a general proposition. Now that's preposterous because the Constitution explicitly authorizes Congress to regulate the territories. One of the first 10 statutes ever adopted by the first Congress, signed by George Washington, prohibits slavery in the Northwest Territory. It builds on a thing called the Northwest Ordinance that was actually already in place even before the Constitution was ratified. It originated from the Congress under the Articles of Confederation. And during the ratification process, the framers are saying that we approve of the Northwest Ordinance. And yes, one of the first things Congress is going to do is prohibit slavery in the Northwest, endorsing the Northwest Ordinance. So if Taney is right, the Missouri Compromise is unconstitutional because it prohibits slavery north of a certain line. Every cabinet officer signs on to the Missouri Compromise, including John C. Calhoun. This is when James Monroe was president. So the Constitution isn't perfect. It doesn't guarantee free soil, as a really good Constitution would have, but it permits Congress to provide for free soil absolutely clearly. And Taney says, oh, you can't do that, which, by the way, means the Republican Party platform of the time is unconstitutional. The Republican Party platform is basically no slavery in the territories. So It's bad that Dred Scott says blacks can't be citizens and they have no rights that whites are bound to respect. That's preposterous. The Constitution doesn't say that. It's really bad when it says Congress can't prohibit slavery in the territories. That's going to be Lincoln's platform. That is the Republican Party vision, and it's not remotely unconstitutional. And the third thing that Taney says is only citizens have constitutional rights. Well, that's not true either, actually. Due process clause of the Fifth Amendment talks about persons, not citizens. Now, all of those aspects of Dred Scott are going to be repudiated ultimately by a series of constitutional amendments, the 13th, 14th, and 15th. And even though you said, oh, the Supreme Court's the last word on the Constitution, not quite. Even before these amendments, the Lincoln administration is pushing back against Dred Scott. Lincoln's administration actually, in an opinion by the Attorney General, Bates, actually says blacks can be citizens and we will issue passports, U.S. passports, to them. And Congress passes a statute, actually, in 1866, recognizing black citizenship, purporting to overrule Dred Scott. And Congress actually, under Lincoln, purports to eliminate slavery in territories in D.C., contra Dred Scott. So they're pushing back hard against Dred Scott. And I think they have the Constitution on their side. So this is a good illustration of my claim that the Constitution isn't perfect, but the court has often been much, much worse than the Constitution. And I'm saying the worst part of the Constitution was the 3/5 clause, because it's going to lead to a pro-slavery electoral college, which will lead to pro-slavery justices being put on the court by pro-slavery presidents.
You're right. The Lincoln administration, Congress, the Civil Rights Act of 1866, they overrule, in effect, the Dred Scott case. I'm, of course, no legal scholar, but even I know that black people could vote in the early republic in some places. They were citizens in some early states.
Right. And the dissenters in Dred Scott say all of that, and they're doing, in a word, originalism. They're saying, actually, the text doesn't support this preposterous claim. Lincoln calls it an astonisher in legal history, Dred Scott in general, but doesn't support what you're saying, and the history doesn't support it either.
The Dred Scott opinion, that was a number of opinions, right? It was just Justice Taney.
There was an opinion for the court by the Chief Justice, but then all sorts of other justices chimed in as well.
And it lands not at any old time in American history. It lands in 1857 after years of excruciating conflict over the future of slavery in the country and in the territories, right? The expansion of slavery. And after, of course, generations of politicians tried to keep slavery out of national politics. Now, Taney says, effectively, slavery everywhere.
Yes, at least where the federal government rules. We're one step away from imposing slavery even in free states. Lincoln very famously, he gives a speech saying, you went to bed thinking that Kansas was going to be free. You're going to wake up and the state of Illinois will be a slave jurisdiction. Because what was Taney's theory? That any place that prohibits masters from bringing their slaves with them violates the due process rights of masters, because you have a right to take your property wherever you want. That's Taney's preposterous theory. Well, if that's so, why is Illinois allowed to prevent you from bringing slaves into Illinois or Massachusetts or Connecticut? And the only thing that prevents Dred Scott from being the nationalization of slavery everywhere, even in free states, is a technical legal doctrine that says, well, strictly speaking, the Constitution's due process clause limits federal land and federal territory, but not the states. But, maybe that's going to change too. As long as Taney's making stuff up, who knows what the limits of making stuff up are.
Yeah. So the aim of my podcast each and every time is to try to link the past with the present. Does Dred Scott hold any significance to this day? Probably, right? I mean, we're still discussing citizenship and rights. We're still in this debate about the place of all people in our country.
Everything. Let's connect the dots to two other things we've already talked about, Martin. First, how to go about interpreting the Constitution. I say originalism. Taney makes originalist claims. It's just they're preposterous, and they are refuted very persuasively on originalist grounds by the dissenters in Dred Scott and by Lincoln, who's an originalist. So an advantage of originalism is there really is a text to parse and historical evidence. So on the originalism, non-originalism debate, is framed, interestingly, by Dred Scott. And again, my claim is courts in general, when they make stuff up, have been, in American history, often worse than the Constitution, and Dred Scott is emblematic. But let's take Dobbs, since you mentioned Dobbs at the very beginning and the leaked Dobbs draft. I happen to be personally pro pro-choice. But I'm very critical of Roe versus Wade. As a judicial exposition, I think it made stuff up. I think the court pulled out rules from its proverbial butt, so to speak. And critics of Roe, the harshest critics, don't just say, oh, this is like the Lochner court that made up all sorts of rights. They actually say the harshest critics of Roe, including Antonin Scalia, for example, it is Dred Scott all over again. And here's why. Let's just go through the eerie parallels. Dred Scott says blacks can't be citizens. Roe versus Wade says fidi are not persons. It's a parallel. It's not an identity, but it's a parallel. Dred Scott takes an issue where states disagree and nationalizes it, comes up with a national rule, and to critics' mind, comes up with an immoral national rule. Slavery everywhere, or at least very broadly. Well, to a pro-life person, that's what Roe does. It takes an issue where states are disagreeing and nationalizes the anti-life position, what they would think is the immoral position. And again, this is not an identity, but they say, oh, that's like Dred Scott. Now, even more dramatically, Dred Scott makes the Republican Party platform unconstitutional. That's what I just told you. Lincoln's vision is to prohibit slavery in the territories. Read my lips, no new slavery, in effect. Prohibit slavery, that is the Republican, and Dred Scott says that's unconstitutional. Well, Roe says today's Republican Party platform is unconstitutional because for the last 40 years, the Republican Party platform has been pro-life. That's one of our two major parties. They won half of the presidential election since Roe versus Wade. And Roe, if taken seriously, is really saying their platform is unconstitutional. Just as Dred Scott was saying, in effect, Lincoln's platform, the Republican Party platform of that era, was unconstitutional. Finally, what's Dred Scott's basis for doing all that? A substantive reading of the Due Process Clause in which courts get to decide what kind of restrictions on liberty and property are permissible. And they say restriction on the property interest of masters, prohibiting masters from bringing their property, their slaves, into federal territory. That's unconstitutional. It violates a kind of idea that lawyers today would call substantive due process. Well, Roe versus Wade is based on substantive due process. It says restricting the reproductive options of women is improper because we decide that the legislature's reasons aren't good enough. Just as Dred Scott said, Congress's reasons aren't good enough in prohibiting slavery in the territories. And so 4 really eerie parallels between Dred and Roe. Critics of Roe say, oh, this is Dred Scott all over again. So yes, we're still living with the reverberations of Dred Scott, methodologically and substantively.
I've never considered those two cases side by side like that. So hear me out here.
Yeah, and let me just tell you one other thing, because you haven't. People used to make fun of George W. Bush. He would say nuclear rather than nuclear. So, but if he was, so doltish, as critics wrongly thought, how did he get elected president twice? In a debate.
Well, there was a Supreme Court ruling.
Yes, but you have to be close enough still. Yeah. And in a debate with Al Gore, a nationally televised debate, they were asked about Supreme Court nominations and what they would do, how they thought about the Supreme Court. And here's what he said. He said, well, I wouldn't appoint any Dred Scott judges. And people laughed, like, doesn't he know Dred Scott was, overruled a long time ago by the Reconstruction Amendments, all the rest? That was a dog whistle. Every movement conservative understood that when he said Dred, he meant Roe versus Wade, and none of the liberals even heard it or understood it. So this is very clever. If in a debate where everyone is watching, you're actually winking to your side and motivating them and not mobilizing the folks on the other side, this was very, very sophisticated messaging on his part.
One last point about Roe, and then I want to ask you about some of these other terrible Supreme Court decisions from the past. Hear me out here. My understanding of how the law developed, if you will, over the 20th century when it came to recognizing a right to privacy. There was an idea, and I know Justice Brandeis wrote about this, the right to be let alone, that rights embodied in the Constitution include rights to personal autonomy. So we get Griswold in 1965, and then Roe versus Wade in 1973. So is there no right to privacy then?
Privacy is an awkward and unfortunate way of thinking about the abortion issue. And to repeat for our audience, I'm pro-choice personally, but here's why privacy is awkward. First, it kind of assumes away the status of the fetus. And if you think that a microscopic clump of cells is really kind of morally nothing at 3 weeks post-conception, okay. But what about actually an unborn human being 33 weeks post-conception? Perfectly viable, could be delivered live, okay? So privacy is an awkward way of talking about an issue where there's another moral entity. That's point one. It's also an awkward way of talking about a procedure that typically takes place outside the home, involving a stranger, a medical professional that you've maybe never met before, will never meet again. Money is changing hands. This is rather different than two married couples choosing to use contraception where there's no life in being in the inner sanctum of their marital bedroom, in a private place involving just the two of them. There are no doctors involved. There's
the Griswold
no
case.
life in being. That's Griswold. But Griswold was on the books, and Justice Blackmun, for whom my brother clerked, actually, and I really respected him, as did my brother, he used the cases that the court had already decided, and Griswold was there, and it talked about privacy, but he himself acknowledged 2 pages after he invoked Griswold, he actually said, well, truthfully, the issue of abortion, and this is his phrase, is inherently different than, say, the contraception case, because actually the pregnant woman isn't really isolated in her pregnancy. It's not really the most private of events when you think about the fetus and the healthcare system that's also involved.
So thank you for that explanation. As promised, we'll move on to some of these other cases that do not put the Supreme Court historically in a very good light. It's been on the wrong side of civil rights cases. We can talk about the Reconstruction era court in the 1870s, but then especially in 1883, the civil rights cases. Then there was a 1927 case, Buck versus Bell, upholding forced sterilizations. 1890s, I skipped. Plessy versus Ferguson, separate but equal. 1944 upholds the internment of Japanese Americans without due process. And there have been some more recent cases that we could discuss, but those are more difficult because we're still kind of in the heat of the moment. We don't have enough separation. But I just named opposition to civil rights, upholding forced sterilizations, internment of Japanese Americans. To your initial claim, the court is often worse than the Constitution.
Yes.
But you, Martin, I guess, let me just, one last point here. You wonder how it's possible, though, to use a term I used before, rights and liberties embodied by the Constitution, right? Yet the court says no.
You're absolutely right, and you're very modest. You say, oh, I don't have a legal education, all the rest. This is a very, very sophisticated understanding of American history and the American constitutional tradition that you've offered. We've talked in some detail about lots of cases, Roe and Dobbs and Dred Scott, but now we're bringing others into the mix. So yeah, let's just look at what the Constitution says. It's imperfect, and what the court does. So the Constitution was pro-slavery, in my view, because of 3/5. It's going to give the slaveocracy an advantage in the presidency. But Dred Scott was way worse because it said blacks can't be citizens, and the Constitution didn't say that at all. And it said Congress can't prohibit slavery in the territories, and the Constitution didn't say that at all. And it said only citizens have constitutional rights, not persons like aliens beyond citizens. And the Constitution didn't say that at all. So Constitution wasn't perfect, but Dred Scott was way worse. Now we have a series of amendments precipitated in part by Dred Scott and by Lincoln's election, running on an anti-Dred Scott platform and the Civil War that ensues. The Constitution promises racial equality and an end to slavery and broad civil rights and broad congressional power to enforce all of this. That's what the Constitution actually says. What does the court do? In, as you said, the civil rights case of 1883, it invalidates a congressional civil rights law. That the Reconstruction Amendments were designed to authorize these. The Civil Rights Law was passed by a Reconstruction Congress, and the court invalidates that, even though the 13th Amendment ends with the words Congress shall have power. 14th Amendment ends with the words Congress shall have power. 15th Amendment ends with the Congress shall have power, and the court invalidates all of that. And by the way, the antebellum court had upheld all sorts of congressional fugitive slave laws, pro-slavery stuff, even though there wasn't clear authorization for some of those. So
it sets us back a century, essentially.
We're going to have to reenact the Civil Rights Act of 1875 in 1964. You're absolutely right. The 1964 Act is basically just a reenactment of the Sumner Bill, the bill adopted in honor of Charles Sumner in 1875, that the Supreme Court invalidates in 1883 over the great dissent, alone in dissent, John Marshall Harlan the Elder. Hold that thought, John Marshall Harlan the Elder, because he again is alone in dissent in the 1896 case of Plessy versus Ferguson. And once again, the Constitution isn't perfect, even after the Civil War amendments, but it really does say racial equality. That's really what it's about. And racial segregation, American apartheid, wasn't equal, yet the court upholds racial segregation in Plessy versus Ferguson. And Harlan says, what are you talking about? It says equal. And it's not going to be until the 1950s and 60s with Brown versus Board of Education and Loving versus Virginia that we actually get back to basically even enforcing the Constitution and what it really says on racial equality. So for the entire period between, let's say, 1890 and 1967 until Loving versus Virginia, the Constitution says equal, 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 and the court isn't doing that. So it's deviating, but deviating in a way that's less attractive than the Constitution. Now, you talked about eugenics and Buck versus Bell. This is a little more complicated because the Constitution itself doesn't have express provisions about every kind of right, unenumerated rights, like the right to procreate. But it does say in the Ninth Amendment, there are unenumerated rights that the federal government has to respect. And in the 14th Amendment, it has a very sweeping, broad promise that states can't abridge the privileges and immunities of citizens of the United States, the fundamental rights, and it doesn't specify them all. Surely and
Article 4, Section 2 mentions privileges and immunities.
So surely there are unenumerated rights, and one of the most basic is the right to reproduce, and the court paid very little attention to that in Buck versus Bell, and it was even worse than that because it was actually a law that purported to sterilize, only feeble-minded folk, but the procedures that were in place were actually a travesty. In fact, the woman who was sterilized was not feeble-minded at all. There were all sorts of ideas about genetic superiority and racial superiority embedded in this whole thing. And the Constitution, when you take it seriously, the text basically says we're all born equal. We're born equal whether we're born black or white or of European stock or non-European stock or Anglo-Saxon versus Eastern European. We're all fundamentally born equal. We're born equal whether we have high IQs or low IQs. We're born equal. That's a profound, radical thought. We're created equal in the language of the Declaration of Independence, and Buck versus Bell actually, I think, gave short shrift to all of that.
Yeah, that's what's so frustrating about some of these cases. Of course, we understand that they're not just delivered in a vacuum, right? People are making these decisions that are products of their time, the prejudices and the biases, and also in the first half of the 19th century, these ideas are still kind of being worked out in a new democratic republic when it came to privileges and immunities.
My claim is, and it's provocative. We'll just have to see whether people agree that the evidence tends to support it. In the very same eras that judges are often disappointing, and sometimes legislatures are as well, we the people in our constitutional text, the original Constitution, the early amendments, what we call the Bill of Rights, the later amendments, the Reconstruction Amendments, still later amendments like women's suffrage, the people, when adopting the Constitution and amending it, are in general outperforming the judges. This is the same 250 years of American history, but if you look at what the people have done in the Constitution's text and amendments, it's actually been more admirable than what the judges or the legislators, do day by day, year by year. So that's an interesting irregularity, if true. I think it is.
Well, if Roe is overturned, the issue does then return to the people, to the states. How do you rate the Roberts Court?
To repeat, it may not be perfect. I'm a Democrat. It's dominated by Republicans, but it's better than the other branches of government today, which are
That's
dysfunctional.
Not saying much, yes.
Yes, but those are our choices in the real world. It's either the imperfect Constitution or imperfect case law. I'm saying the imperfect Constitution is better. I've testified before Congress on many occasions. 4 of my former students are senators of the United States. There are only 100, and 4 of them are my students. And I say when I testify before Congress today, it's dysfunctional. The House is a snake pit. The Senate is not at all as impressive as it used to be. They're all just, tweeting and
performing.
and dialing for dollars.
And hiding behind a word that is not in the Constitution. Filibuster. I understand the Senate can make its own rules, but the Constitution does say simple majority for legislation.
I'm with you on all that. I am the architect of the nuclear option, in fact. Gary Hart and I wrote a piece long ago on all this. So what I am saying is the presidency, in my view, Donald Trump was not fit for the presidency and put the entire democratic constitutional project in peril. So the presidency is dangerously dysfunctional today. The House and the Senate are not firing on all cylinders. The court is imperfect, but it's the one place, the Roberts Court, where, for example, conservatives sometimes vote with liberals. They cross the aisle, even in important cases. They never do that when it really matters in the House or Senate. But John Roberts, who is an absolute rock-solid Republican, votes 3 times with the libs to uphold Obamacare, which was a Democratic Party measure. And no Republicans really supported it in the House or Senate, but Roberts 3 times, in a case called Sebelius, in a case called King versus Burwell, and another case involving California and Texas, voted to uphold Obamacare. He doesn't like it as a policy matter, but he thinks it's constitutional. I'm with him on that. Even if you disagree, wow, that was nonpartisan. He's a Republican voting with the Democrats. And he joins Neil Gorsuch to sweepingly affirm rights of LGBT folk in the workplace in a case called Bostock. And you might agree with him, you might disagree with him, but wow. In the run-up to 2020, Roberts and Kavanaugh actually declined to embrace certain radical legal theories that, might have tried to deliver the presidency to Donald Trump, things that are closely connected to Stop the Steal, called independent state legislature theory. Good for them, not just beyond the Roberts Court, but the judiciary in general. Lots of Trump-appointed judges up and down the food chain actually heard lawsuits brought to overturn the election and
50.
said these are bogus.
Yeah, 50 of them.
So good for them, because actually that's a better, again, this is comparative. How does the Constitution compare to the court? How does the court compare to the other branches? This is, in general, an impressive track record compared to the House, Republicans in the House, for example, or just partisans generally, or the Senate, or the presidency. These are smart lawyers who do their own work, who read the briefs, who think hard, who aren't spending all their time on Twitter dialing for dollars, just tweeting snark, performing. They're not perfect at all, but I respect them across the board.
Akhil Amar, we thank you for this great conversation. On the next episode of History as It Happens, the Democrats and blue-collar labor.
The 4th of July commemorates our political freedom, a freedom which without economic freedom is meaningless indeed. Labor Day symbolizes our determination to achieve an economic freedom for the average man.
Why is FDR spinning in his grave? That's next as we report History as It Happens, a podcast from the Washington Times.